And Madam Secretary, please call the roll.
Senator Chambers Armstrong. Here. Senator Howell. Here. Senator Nemes.
Present.
Senator Thomas.
Here.
Senator Tishner. Here. Senator Williams.
Here.
Chairman Storm.
Present. We have all members present. We have a quorum. We're duly authorized to do business. And again, as I stated, this is the impeachment trial of Ronnie Lee Goldie Jr. Is Mr. Goldie present in the room, or is any representative on his behalf here with us today? Seeing no representative or Mr. Goldie himself, representatives, if you could just identify yourselves for the record.
Good morning, Mr. Chairman. I'm Daniel Elliott. I'm state representative in the 54th District, Boyle and Casey counties. I served as chairman of the House Impeachment Committee.
State Representative Nima Kulkarni. I served the 40th Legislative District, and I was serving as a member of the Impeachment Committee.
Jason Nemes, State Representative for the 33rd House District. That's Jefferson, Oldham, and Shelby counties.
For the record, are there any preliminary motions that need to be taken up by this body?
There aren't, Mr. Chairman. I did want to recognize the other members of the House Impeachment Committee who are here. Representative Suzanne Miles, Representative Jennifer Decker, Representative Kim King, and we also had Representative Lindsey Burke, and I don't think she is here, but she did serve with us on the committee, and so I did want to recognize their efforts.
Thank you. And again, for the record, do we have verification of service of the precept to appear in the record on behalf of Mr. Ronnie Lee Goldie?
Mr. Chairman, David Flainer, General Counsel to the Senate President's Office. I served him on the 28th of February and the 8th of March, and I did receive the card back from the post office. I have had some communications with his attorney who indicated he would not appear today, but he has been served with a notice of the time and hearing.
Very well. So we do have valid service and have had some correspondence with the attorney of record. Would you like to make an opening statement, representatives?
Yes, we would, Mr. Chairman.
Please proceed.
Thank you and good morning. Good morning, Mr. Chairman, members of this committee. Today we're here to discuss an extraordinary matter that's come before the General Assembly. One of the more somber duties we have as legislators is maintaining the integrity of public offices. As the Constitution dictates, this includes removing bad actors from office. The Kentucky Constitution highlights this duty directly and says in Section 66, the House of Representatives shall have the sole power of impeachment. In Section 67, all impeachments shall be tried by the Senate. And in Section 68, the governor and all civil officers shall be liable to impeachment for any misdemeanors in office, but judgment in such cases shall not extend further than removal from office and disqualification to hold any office of honor, trust, or profit under this Commonwealth. On Thursday, January the 5th, Representative Jason Nemes filed House Resolution 11, which directed the appointment of a committee to determine if there was sufficient evidence to impeach Commonwealth's Attorney Ronnie Lee Goldie Jr. At that point, myself and members from the 7th, 33rd, 40th, 55th, 58th, and 75th House District were tasked with reviewing all evidence pertaining to any alleged misconduct committed by Mr. Goldie. And to walk you through those proceedings, Mr. Chairman, the House Impeachment Committee received and reviewed the record of the special commissioner appointed by the Supreme Court to cover the disciplinary action against Mr. Goldie. This included 5 hours of hearing video, roughly 190 pages of documents and communications between Mr. Goldie and a female criminal defendant. And as a preliminary matter, we have submitted those records to this committee for its detailed review, and as you can see, they are voluminous. Since this is not a judicial proceeding but a legislative one, we will not be walking through every individual piece of evidence. Instead, we will give you an overview of the matters and answer any questions that you may have. And to get the best understanding of the case, we believe you really need to review the evidence for yourself. With that out of the way, to say that the subject matter of these communications between Mr. Goldie and the defendant was egregious would be an understatement. And in his testimony, Mr. Goldie called these communications with the defendant normal procedure for the Commonwealth's Attorney's Office. These communications regarded ongoing cases against the defendant. And it should be noted, Mr. Chairman, that all of these communications were done without the defendant's counsel present. I could argue that this ex parte communication alone constitutes an impeachable offense, but the details make the situation much worse. Mr. Goldie requested illicit photographs and videos of the female defendant in exchange for favorable actions in cases against her in which he was prosecuting. And he would also occasionally send her money, admitting to sending her at least $25. This went as far as Mr. Goldie communicating with judges and Commonwealth's attorneys and other judicial circuits in hopes for a better outcome for her. As an aside, and you will see in the hearing video, Mr. Goldie claimed to have little to no knowledge or possession of these communications. However, in his response to the House committee, he produced copies of these communications as a defense, effectively confirming that he did in fact have them. Bizarre defense strategy aside, Mr. Chairman, this is confirmation of textbook quid pro quo behavior. And the House committee determined that these offenses constituted a misdemeanor in office. In this context, misdemeanor does not carry the same meaning as it does in criminal cases. In this sense, it means not only misuse of the power the office holds, but betrayal of public trust. As the first article states, the committee found that because of the actions that I have just highlighted, Mr. Goldie engaged in conduct that resulted in a suspension from the practice of law from the Supreme Court of Kentucky. And the Supreme Court found that his conduct posed a substantial threat to the public and a risk of harm to his clients. After the evidence was reviewed, the committee agreed that the testimony from other Commonwealth's attorneys was necessary. And on February the 2nd, the committee heard from Commonwealth's attorneys Jackie Steele, Rob Sanders, and Brian Wright, who additionally serve as members of the Commonwealth Prosecutors Advisory Council, and Mr. Wright is here, Mr. Chairman, as well. They commented that until now, there's never been a Commonwealth attorney who had been expelled from the association, and that the weight of this action alone was noted through the committee hearing, and I believe should be emphasized to this committee as well. In fact, I would be remiss if I did not mention that the association had to change its bylaws specifically in order to expel Mr. Goldie, based on the fact that there was ex parte contact with the defendant without her attorney present, regardless of its nature, was deemed outside the bounds of what we as prosecutors deal with on a daily basis, was one of the quotes. And Mr. Chairman, I believe I speak for the entire impeachment committee that when I say that for a sitting Commonwealth attorney to be both expelled from their association as well as being suspended from the practice of law is an indication that that person is no longer fit to serve in public office. Because Mr. Goldie is no longer licensed to practice law, he couldn't carry out the duties of his office. And in fact, he does not even qualify for election to the office in which he was serving. To execute the duties of Commonwealth attorney, trust is integral. The citizens that a Commonwealth attorney serves should be able to have faith in the duties instilled in him or her and that those duties are carried out. And in order for the system to work, everyone from police officers to court clerks and even up to judges must be able to rely on the Commonwealth Attorney to carry out their duties both effectively and fairly. And after reviewing all the evidence, Mr. Chairman, members of this committee, our bipartisan group of House members determined that action must be taken. And that's why our committee recommended that articles of impeachment be adopted by the House. And that is why the House of Representatives unanimously adopted those articles of impeachment. So there are three distinct articles, Mr. Chairman, that the House adopted for your consideration against Mr. Goldie. And just to briefly, I'll go through those and read those, Mr. Chairman. Article 1 states that during his term of office, Ronnie Lee Goldie engaged in conduct which resulted in a suspension from the practice of law by the Supreme Court of Kentucky with a finding of probable cause that his conduct posed a substantial threat or risk of harm to his clients or to the public, and the order from the Supreme Court required him to notify all of his clients in writing that he could no longer provide further legal services, that his inability to provide those legal services in which he was elected as a result of the suspension from the practice of law violated the rights of the people to have confidence in their elected officials, to perform the duties for which they were elected, and that constitutes a misdemeanor in office, and pursuant to Section 68 of the Constitution is an impeachable offense for which removal from office and disqualification to hold any office or trust or profit under this Commonwealth is warranted. In Article 2, Mr. Goldie engaged in personal communications with a defendant in the 21st Judicial Circuit regarding that defendant's pending criminal cases, that he discussed those criminal matters with the defendant directly without her counsel being present, and intervened on the defendant's behalf in various criminal proceedings, and that these inappropriate communications and actions are a violation of public trust and constitute a misdemeanor in office. And pursuant to Section 68 of the Kentucky Constitution, this is an impeachable offense for which removal from office and disqualification to hold any office of trust, honor, or profit under this Commonwealth is warranted. And in Article 3, Mr. Chairman, during Mr. Goldie's term of office, that he requested and received inappropriate personal information from a defendant in the 21st Judicial Circuit as quid pro quo for actions he took in his official position as Commonwealth Attorney on behalf of that defendant, and that this conduct constitutes a misdemeanor in office under Section 68, is an impeachable offense for which removal from office and disqualification to hold any office of trust or profit under this Commonwealth is warranted upon judgment. And so, Mr. Chairman, it's at least my opinion that any of these three constitute a removable, if I can speak this morning, removable offense that the Senate should find Mr. Goldie guilty of. And taken together, the case for removal is, we think, crystal clear. Simply put, these acts committed by someone entrusted to carry out the law cannot be excused. As this committee may be aware, Mr. Goldie has already resigned. That was effective February the 28th, but frankly, that's not enough. And the purpose of impeachment is not just to force bad actors to resign, it is to ensure the public trust cannot be further betrayed. And to put it simply, Mr. Goldie cannot be trusted with any public office and should be barred from seeking one in the future. To directly quote Mr. Rob Sanders, who provided testimony to our committee, if not now, when would you ever impeach a Commonwealth attorney? Short of killing someone or committing another violent physical offense, as far as ethics goes, this is as unethical as it gets. And I want to also read a quote from Mr. Wright, Goldie's response was attempting to somehow explain his conduct, and the conduct is just simply inexcusable. These are terrible, awful allegations, and I don't see how he can stay in office, and I don't know how there could be a reasonable explanation for this. And to this committee, I ask the same question: when is enough enough? Where will we draw the line? Will we condone this sort of behavior, or will we send a message that this kind of conduct is simply unacceptable? That, Mr. Chairman, is a summary of the proceedings up to this point. We have submitted the record for this committee's detailed review, and at this time I would defer to my fellow House members to make any remarks that they have this morning, if the committee will permit that.
Just a moment, Representative. Is that your opening statement? And do you
Yes.
all have presentation of evidence following the opening statements? Because I want to make sure that we have it give Mr. Ronnie Lee Goldie Jr. or anyone acting on his behalf or representing him an opportunity to make an opening statement if they so choose.
That's just the opening statement at this point, Mr. Chairman. In terms of a presentation of evidence, we felt it was more appropriate for the committee actually to review this record, and then if we did need to come back in the future to present evidence, then we would be willing to do that. But we think it would be more fruitful for the committee to actually have an opportunity to review this record that we're going to submit.
Hold on one moment. Just so the record's clear, would these other individuals have information regarding the opening statement, or would this be presentation of evidence?
It would be opening statement.
Okay, that's fine.
Yeah,
Please
is
proceed.
my understanding, unless they correct me, Mr. Chairman.
Please proceed then.
I thank you, committee members. I don't have too much to add to the very thorough opening statement that Chairman Elliott just provided. I will say that,
Can you pull your mic up just a bit? I'm sorry.
I apologize. I was just mentioning that I don't have too much to add to the opening remarks by Chairman Elliott. I will say that our committee made this decision unanimously to recommend impeachment, and I believe that the record is fairly thorough and extensive and established clearly that Mr. Goldie in his capacity presented a substantial threat of harm to the public. The Bar Association appointed a special commissioner who had provided an opportunity for Mr. Goldie to present a defense. There was an extensive record of that defense. The Supreme Court adopted the commissioner's report and recommendation for suspension from practice in the Commonwealth in its entirety. We heard from the Commonwealth's attorneys, and we have direct evidence that was provided by Mr. Goldie with regard to the messages. So I would simply say moving through the record would provide this committee as well with significant and substantial evidence of Mr. Goldie's misconduct.
Thank you, Mr. Chairman. I would note, associate myself with comments of both of my colleagues here. In particular, I want to say this is as bad as it gets. We're talking about doing favors in return for pictures, for nude pictures and videos. We're talking about the giving of remuneration money to a defendant over which this prosecutor has authority, obviously. We're talking about communications directly with that defendant. And for the non-lawyers on here, that is a problem. Obviously, when it's a civil case, it's a bigger problem when it's a case in prosecution. The Supreme Court has taken this up, and Judge Logue was the special commissioner. I know a lot of us know Judge Logue and have thought very highly of her for decades. And after taking testimony from Ms. Helton and Mr. Goldie and others, she found probable cause to believe that Ronnie Lee Goldie Jr., while serving as the Commonwealth Attorney for the 21st Judicial Circuit, engaged in personal communications with Misty Helton, a defendant in the 21st Judicial Circuit, regarding her various criminal cases. He discussed Ms. Helton's criminal matters with her directly, without her counsel being present, and clearly intervened on her behalf by having court dates moved or warrants recalled. In return for his actions, Mr. Godey solicited nude pictures and videos from Ms. Helton. Throughout his testimony, this is a quote from Judge Loke, throughout his testimony, Mr. Godey shows a complete disregard for Supreme Court Rule 3.140, paren 4.2, close paren, regarding communication with a person represented by counsel. And based upon his testimony, the Special Commissioner found, quote, Mr. Godey's relationship with Ms. Helton was not in the normal course of business for a Commonwealth attorney, close quote. Just to highlight one interaction, on June 15th, we asked, I think the question was, did this happen on June the 5th? And he said, no, it didn't, but he didn't explain it. He's right, it didn't happen on the 5th, it happened on the 15th. He was asked by he asked Miss Helton, when do I get to see a video? And she replied, when do I not have a warrant? Ha, ha, ha. His response was that didn't happen on the 5th. Well, he's right, it happened on the 15th. Later, he says, incentives never hurt. And so there's a clear request response. There's a quid pro quo here of I think a very significant matter. And when asked, the House Chairman, Mr. Elliott, asked 3 prosecutors to come to the committee because we wanted to know, how bad is this? We know it's bad, but how bad is this? Is it bad enough to not only to remove, but also to suggest to the Senate that this gentleman never be able to run for any office again in the future? And the Kenton County Commonwealth Attorney responded and said, I don't know if you're allowed to prohibit someone from only running for a certain office, but I certainly don't think he should ever be Commonwealth Attorney again. And I can't stress to you enough that I don't take this impeachment lightly, nor do I take publicly condemning another Commonwealth Attorney lightly. I don't think any of us do. In fact, I don't think anyone in the Commonwealth Attorneys Association took it lightly when we expelled him from our association. But from what I've observed, no, he can't be trusted with this most trustworthy position. And if that means we have to ban him from running for coroner or constable or any other office, then so be it, because it's that important. So I was trying to figure out, do you think that it's so bad that he should never be able to run for any office again? And all 3 of the Commonwealth attorneys that appeared before our committee agreed that it was that bad. The reference to the coroner and those other things, that's because our Constitution says that you guys have the authority in the Senate, and ladies, to bar him from running for any office of trust or profit. That's the language of the Constitution. So I think it probably is not allowed that you disable him from running for Commonwealth Attorney, but it's any office in the Commonwealth. So we stand united, Republicans, Democrats, people on the impeachment committee, and all members of the House of Representatives, in our belief that this gentleman not only should have been removed from office, and the chairman's actions and our actions behind our chairman led him out of office, but also that this gentleman should never be able to run for a position of trust again in the history, in the future. With that, that's my opening. That when you look at the evidence, it's rather damning, and it's in his own words. Thank you, Mr. Chairman.
Thank you. Just for the record, is anyone here on behalf of Ronald Lee Goldie Jr. to present an opening statement or opening remarks, either himself or representative? Seeing none in the room, do you have any witnesses you'd like to call?
Mr. Chairman, I would like to make one further point, if I might, that I think I failed to make in my opening comments. The position of Commonwealth Attorney, as the attorneys on the committee know, is a position that allows that individual, if they bring charges against someone, to bring the justice system, the entire criminal justice system, down upon a citizen. And I think that the vast power imbalance that Representative Nemes has indicated with the interactions that the Commonwealth Attorney, Mr. Goldie, was having with this defendant is particularly egregious when you think about a situation where that person is prosecuting you, and they're in some ways holding your freedom in their hands. And so that the egregious nature and the power imbalance that exists there, I think, is particularly horrible, and one of the reasons that we clearly moved forward in what we did. Mr. Chairman, we do have Mr. Wright, who is with us, who is a Commonwealth Attorney in Casey County and Adair County. He has previously provided testimony to our committee, but I know at the request of this committee, he is here today, and I think he would have comments, and maybe I know he'd be willing to answer any questions that this committee might have of him as well. And so,
Would you like to call that witness?
absolutely, we can do that.
If the witness could please come and be sworn. Once you're situated, if you could just please identify yourself for the record, and then you may proceed.
Sorry. Good morning, Chairman Storm and members of the committee. Brian Wright, I'm the Commonwealth's Attorney in the 29th Judicial Circuit, which consists of Adair and Casey counties.
You want me to proceed, Mr. Chairman?
Yes, please.
Mr. Wright, you have had an opportunity to review the evidence in this case, and you previously testified before the House Impeachment Committee regarding Mr. Goldie's, the inquest into Mr. Goldie, the impeachment of Mr. Goldie. Would you tell this Senate committee what jumped out to you, the first thing really that when you reviewed this evidence?
Sure.
What were some of the impressions that you had?
Well, the first thing, and I'll agree with what Representative Elliott and the other members, Representative Nemes, had said, the comments that they made up here in their opening statement. I will agree with everything they said about the egregious nature of these messages. But the first thing that jumped out at me, there's a few things that jump out as to me at being extremely egregious and unlike any conduct that any Commonwealth attorney that I know engages in or expects any other prosecutor to engage in. The first was the amount of ex parte contact that Representative Nemes alluded to. There's an enormous amount of contact going on between a prosecutor and a defendant, and part of that had to do with a case where he had recused and there was a special prosecutor appointed. So it was unclear to me what his purpose was in injecting himself into that case at all. So that was the first thing. That was the ex parte contact rather. But the most egregious part was the nature of the communications themselves, not just the fact of the communication, but the nature of the communications. There were exchanges clearly of nude photographs, and there was request after request after request for these videos. And it was clear that those videos are inappropriate in nature. He was looking for nude or naked videos, and in his response, he says he never used those words. But there's no way to read through the context of those messages and come away with any conclusion other than that's what he was asking and almost begging for by the time he got through several of those messages. It was over and over and over again. So the nature of those communications, that he wants inappropriate contact. Then to say about, the comment about incentives never hurt, and talking about incentivizing her to produce things to him in exchange for him taking direct acts that fall within his discretion as Commonwealth's attorney, requesting a judge to withdraw a warrant, getting court dates moved around, talking to other prosecutors and the judge about getting a car released or a cell phone released from evidence. Those are things that he was doing in his capacity as Commonwealth's attorney that another citizen that's not a prosecutor couldn't just go to the judge and say, hey, withdraw this warrant and not give some reason. He had, by virtue of his office, some degree of influence with the judge that he felt that the judge almost certainly felt like there was some legitimate reason why he was asking for that, unbeknownst to the judge. Presumably, he's doing this in exchange for hoping to get videos or pictures. The other thing that, and I know Jackie Steele commented on this, and it really struck all of us, was the commentary about the other drug court participant within those messages. And it not only showed that he was wanting to go to a strip club or an adult entertainment joint to watch and spend money, but he made it clear to her, to the lady he was talking with in the messages, that you know me, you know I'm not going to get her in trouble with drug court for working there. I'm not going to tell anybody. And to me, that's a complete and utter disregard for the purpose of drug court, which is to try to help people. It was for his own entertainment or his own indulgence that he was going to allow her to be in a situation that he knew and that the other lady knew she shouldn't have been in as a drug court participant. So he was going to completely disregard his duty to the drug court team in that circuit. So there was just a complete disregard throughout those messages of the oath that we take as officers of the court, as Commonwealth's attorneys, as prosecutors, to deal with people fairly and above board, and it just seemed to me to be egregious throughout. But those are what jumped out at me: the nature of the messages, the fact that he was contacting a person ex parte, that he was offering to do things regarding warrants, offering to do things in his capacity as a Commonwealth's attorney in an inappropriate way. So that's what jumped out at me.
And Mr. Wright, when you're a member of the Prosecutors Advisory Council and the Commonwealth Attorneys Association, when your group realized some of the conduct that was being alleged against Mr. Goldie, what did your Commonwealth attorneys as an association do in order to disassociate yourself from Mr. Goldie?
Well, the association did the only thing we could do, and that was to expel him after amending our bylaws, to expel him from the association. And, unfortunately, we don't have any further powers to do anything else. The only thing we could do was to expel him from the association, and that's largely symbolic, but it was the most symbolic thing we could do to distance the association from his behavior, his conduct. But it also expelled him, and it prohibited him from attending the functions of the association, the training the association puts on, the meetings. But that was really the only thing the association could do, and we took that step to do it.
Was that the first time that had ever happened to your knowledge?
So there were actually two Commonwealth attorneys that were expelled during the same meeting. I'm not sure which came first, but that was the first meeting during my tenure as Commonwealth's attorney that's happened. And I've been a member of the association. I started out in 1998, and all but a couple of years, 4 years, I've been a member of the association since 1998. And that's the first time that I remember that happening in those years.
Would you talk briefly about the power imbalance between a criminal defendant and a Commonwealth's attorney, and how a defendant would perceive a Commonwealth's attorney who has charged them with a very serious crime, felony level crime, obviously, to be in circuit court, to engage with a defendant in that way, and what effect that has on really the criminal justice system as a whole?
So the power imbalance begins before, you're talking about it at the time they charge. I mean, it actually starts before that. A Commonwealth's attorney makes a lot of decisions as far as charging, as far as presenting a case to a grand jury. We have a duty to only present cases that we think merit an indictment and that we feel can be proven in court. So we have to use broad discretion in determining what cases to present to a grand jury, what cases to pursue, advising police officers on decisions they make. And then that carries through to the charging decisions, to recommendations on sentences, recommendations on pretrial diversion applications, recommendations of probation, recommendations of amending charges in plea agreements or presentations in front of a jury, and in recommendations on issuing or recalling warrants. Now, that discretion ends with the judge. They're the ones that make the decision to issue or withdraw a warrant. But oftentimes Commonwealth attorneys do have input and make recommendations that, like I said earlier, a private citizen can't just walk in and say, hey, judge, issue this warrant, and here's why, or withdraw this warrant, and here's why, or recall this warrant, and here's why. A Commonwealth's attorney has, by virtue of the office, the authority and responsibility of that office, they have certain additional influence, I guess you would say, because a judge relies on them, and defense attorneys rely. If a Commonwealth's attorney comes into court and makes representations that, hey, this judge, this has been reported to me, or I've got this proof that I can present in a hearing, I want a probable cause warrant to be issued, defense attorneys and judges alike put trust that a Commonwealth attorney is going to be above board with the court, and they're going to follow the rules of evidence, the rules of the Supreme Court, and do that in an appropriate manner, clearly unlike what we saw in this case.
Thank you, Mr. Wright. Do you have any questions you want to ask? Okay. I don't think I have anything further, Senator.
Thank you. For the record, at this time, it's Mr. Ronnie Lee Goldie or his representative's opportunity to cross-examine this witness. Seeing no one here on Mr. Goldie's behalf, and Mr. Goldie not here in his own capacity, there is no cross-examination by that individual or his side of the case. Do we have any questions from members of this committee of this witness? Seeing no questions of anyone on this committee of this witness, do you have any further witnesses?
I don't, Mr. Chairman. I do want to make sure that we move to introduce the record from the House Impeachment Committee to this committee, and that we do that formally as an exhibit at the appropriate time.
For the record, if you don't mind, I just have a few follow-ups regarding that. The materials that you wish to submit, would those be submitted as one exhibit? Would they be multiple exhibits?
I believe it might be easy to do it as one exhibit. I know it's a multifaceted document, but I think it might be easier to submit as one exhibit. We do have a list of what it does entail,
Okay.
Mr. Chairman, so that might make it easier for the committee.
And for the record, how were those items obtained, and were those items previously used in any other court proceedings or administrative proceedings?
Yes, Mr. Chairman, it's a certified copy of the record of the Supreme Court and the record submitted at an inquiry commission hearing. And so those were also the text messages that are part of this record were sent by Mr. Goldie himself to the House Impeachment Committee. And then, of course, we have the testimony of Rob Sanders, Brian Wright, and Jackie Steele, certified copy of that, and they testified before the committee, and that is available by video.
And so the record is clear. There's a binder, and then there's also a thumb drive. Is that accurate?
There is. There appear to be two of these, and we have a record of the Inquiry Commission and a certification of the Kentucky Supreme Court as to the authenticity of those exhibits.
Stand at ease a moment, please.
Thank you.
Do you want me to just grab them separately? 3, 4, and 6.
Mr. Chairman,
Yes, please.
whether you
proceed.
do it by one exhibit or 2 or 3, I wanted to just make sure we identify what we have. In the binder that we're hoping, once you admit into the record, that we can pass out to the members that we've, at the chairman's authorization, put together for you guys, there's a certified copy of the record of the Supreme Court and record submitted at the Inquiry Commission hearing. That'll be in the binder, big binder. There's also a thumb drive that we received. It has 3 things on it: recordings from the Inquiry Commission hearings as part of the Supreme Court records as one, recording of Godey's testimony, In Judge May's matter as part of the Supreme Court record, that's 2. And then the third thing that's on the thumb drive is a recording of the testimony of Rob Sanders, Brian Wright, and Jackie Steele before the House Impeachment Committee. That's the third thing on the thumb drive. And then we also have in a red folder, which is in a packet, and those are Bates stamped, so they have the numbering at the bottom, the text message that we received from Mr. Godey. That's probably where I would start looking if I were a member of the Senate looking at the documents. But obviously all the evidence is important. But those text messages are in his words and the lady's words. So that's what I think our chairman would like to ask to submit to the record, whether it's 1 exhibit or 3. It's your pleasure.
Is there any objection by Mr. Ronnie Lee Goldie Jr. or anyone acting on his behalf here today to the admissibility of those records? Seeing no objection, those items will be admitted collectively as Exhibit A or Exhibit 1, whatever please the
Should
House.
we hand those out now?
Whatever's most simple.
That's fine.
My request, Mr. Chairman.
Representatives, does that conclude your proof in the matter regarding Ronnie Lee Goldie Jr.?
It does, Mr. Chairman.
At this time, we'll transition to proof by Ronnie Lee Goldie Jr. or anyone acting on his behalf to offer a defense in this matter. Not seeing anyone coming to the table to represent Ronnie Lee Goldie Jr. or not seeing Ronnie Lee Goldie Jr. himself, there will be no defense offered before this committee and before the Senate regarding the impeachment trial of Ronnie Lee Goldie Jr. At this time, would you like to make a closing statement?
I would not, Mr. Chairman, but I would thank the members for their service and appreciate it very much.
And for the record, would Ronnie Lee Goldie Jr. or anyone acting as a legal representative of Ronnie Lee Goldie Jr. like to come forward to offer a closing statement? Seeing neither Ronnie Lee Goldie Jr. or anyone acting on his behalf, this body will stand in recess until the call of the chair. Thank you. Representative Elliott, will you all be available throughout the day as this committee reviews this material? Okay. I think we may have to recall you all if we have any questions. Thank you. Yes. Thank you.